Go live on Facebook. Everything looks good, so you can start whenever you are ready.
Okay. All right. Hi, everybody. My name is Robert Hill. I'm an attorney with Legal Aid of North Carolina. I'm here today to help present the Social Security Disability Clinic, where hopefully we'll cover some good information on Social Security disability application process and appeal process. But first, I just wanted to say sorry in advance if I sound a little odd. I'm a little under the weather. Excuse me. I'm a little under the weather today. So sorry in advance if I sound a little scratchy or odd. But this is part of a series of clinics that Legal Aid has been putting on a number of topics there on your screen. You'll see housing, employment, education, and others. So definitely take a look at our backlog of videos and keep an eye out on our future clinic schedule. I think it's posted up on our Facebook. And we cover a lot of great stuff. I have a lot of great attorneys talk about some really helpful information. So there's more on the clinics there. Divorce, Medicaid. The Medicaid clinic that started recently has been really, really great. So I definitely would recommend, especially the Medicaid clinic, but the others as well, child custody and employee rights are all fantastic. Okay, but we're here today to talk about Social Security disability benefits. So there's a whole lot of confusion on this topic, understandably. There's a whole lot of acronyms and it changes from time to time and a lot of misconceptions out there about it. So hopefully we can clear some of that, but I'm welcome any questions at all. If anybody has any questions, feel free to submit them anytime and I'll try to answer them as soon as I see them. And then at the end here, we'll be happy to take some more questions as well. So first things first, the basics. What is Social Security disability or disability benefits in general? I think it can mean something a little bit different than most people tend to think of it. So when people say just regular, in regular conversation, people say, I'm on disability or I'm seeking disability or something like that. That can mean a whole bunch of different things. It can mean everything from, private employer-sponsored, short-term disability programs, but more commonly, I think it refers to Social Security or Social Security disability. So there's two main categories of Social Security disability. When people say, I'm applying for disability, that can mean two different things. And that's SSDI versus SSI. These two programs use exactly the same framework when it comes to medical considerations. So when Social Security, the administration, the agency, Social Security, is deciding whether or not someone is disabled medically, they're going to use the same exact framework regardless of the program. And we'll go over that in just a minute. The difference between the two programs is on the financial side primarily. And that has to do with work history. So you become eligible for SSDI, disability insurance, if you have a certain amount of work history, relatively recent work history. So it's they have a really specific formula for it, but I think as a rule of thumb, it's just some substantial gainful activity that was performed in the last 10 years. They rose to above the threshold there, and it explains there on the screen a little bit more. They talk about it in terms of credits of work over the years, but really it's, do you have a recent work history? If you do, then oftentimes you're going to be eligible for SSDI. If you don't, then you still can apply and seek disability benefits. It's just that you're going to be on the SSI program. And again, the main difference there is financial. So if you're on terms of benefit amounts, SSDI amounts are typically higher than SSI. So I think the average SSDI monthly benefit amount is closer to, I think, $1,200 or $1,500 a month, whereas SSI is a fixed amount that's only adjusted each year based on inflation. So last year it was $794 a month. This year I think it's $814, I believe, per month. Whereas SSDI, the amount you receive per month can fluctuate depending on how much you worked in the past and what your income was in the past. So it can fluctuate. But it also impacts how you handle your finances going forward. So if you apply for Social Security disability and you discover that you will be an SSI recipient, so you don't have enough recent work history to qualify for SSDI or other reasons, and you have to be on SSI, then the biggest thing you need to know is that you have an asset limit. And so that right there on the screen is $2,000 for an individual or $3,000 for a couple. So what that means is that if you're on SSI, and this is a really important point we find a lot of clients run into trouble with, but if you're on SSI, you cannot have more than $2,000 approximately in assets. Now, they don't count all of your assets. They won't count your primary vehicle. You know, if you have one car that you need to use to get around, they're not going to count that as an asset. They usually won't count your primary residence as an asset. But they will count money in the bank, and they will count other things, other property you might own, other cars you might own. Those can add up to $2,000 surprisingly quickly. So for example, if you have one extra really old car, maybe, that's just worth $1,000. But then in your bank account, you have $900, and then 1 month that goes over to over 1,000. Then you could be in trouble there, especially if it stays that way for an extended period of time, because you're going to be running into your $2,000 asset limit. So that's the main thing I want to highlight about the differences between these two programs is the financial sides of things. But they both use the same medical framework. Before I go on though, of course, there's a sort of a third, although really this falls under SSI, but there's something maybe not everybody's aware of is that there's disability is also available to children. So they use different medical standards here because different analysis for children though, because when analyzing a child, of course, you don't look at their ability to work, you look at their developmental capacity and developmental progress. So that's the main difference for child benefits, but that they fall underneath SSI, so they will have the same asset and income rules as SSI, in that it applies as for the child's parents. So the child's parents should be wary of going over $2,000 in assets and those sorts of things. But disability benefits are available for children. They use a little bit of a different analysis process, looking at how well the child, if their fine motor skills, for example, are age appropriate, if they have learning delays, other kinds of delays. Those will often be reflected in a child's IEP plan if they're in school. Their individualized education plan will sometimes be a signal to a parent that they may consider applying for SSI if the child's already on in a special education program or receiving an IEP plan. Then they will discuss the same developmental areas that SSI considers a lot of the time. So definitely if you know someone who you think may financially qualify and is facing developmental issues at school, this may be something they want to look into. But for today, we're mostly going to focus on adult disability programs. I think the child disability program would be a great topic for a future clinic as well. Okay, so let's start at the top. So let's say that you're interested in applying for disability benefits. If you're not sure where to start, I always suggest first place to go to is the Social Security website. Right there, there's a link on the screen there for a benefit finder. That just is a very initial benefit screening tool so that you can plug in just a little bit of information about yourself and see what Social Security, what kind of tentative answer Social Security might give you. So that way you can be, if you're not sure about certain issues, you can at least do a tentative screen. It's not always going to give you a definitive answer, but it may help flag some issues for you to be aware of as you start the process. It's just a good step 0 first stage. Okay, so let's talk a little bit about what it means to be disabled under Social Security law. So the lay definition, in a way, mirrors the Social Security's definition. It's do you have a severe or more than one severe health condition that's going to last for at least a year or permanently until death that prevents you from doing the type of work you did before and prevents you from adjusting to some other substantial gainful activity. So again, it's do you have a one or more severe conditions that prevents you from doing what you've done in the past and will keep you from doing other work in the future. And so they break that's the definition of Social Security, what being disabled means in Social Security. And again, the reason why I highlight this definition here at the beginning is because I think a lot of people have the misconception that it's purely about the medical conditions. When most of the time, in almost every case, it's going to be not only about the medical conditions that you may have, but also about your remaining capacity to work, even with those medical conditions. So you may have severe medical conditions, but are they going to be so severe that they prevent you from engaging in work activity? And that work activity component often just is not something people consider when they're thinking of what disability means. Okay, so here is the overarching framework for how Social Security analyzes any sort of case, just about any sort of case. I know it says 5-step, and that third one there, the third box is more of a 0.5, more of a middle step. So sorry that there's 6 boxes, but it's still called the 5-step sequential analysis process. And this is how the judge and lower level Social Security workers are going to look at a case when they're deciding someone's disabled. So I think it's really helpful for claimants to have an understanding of the context of what the judge or what Social Security is going to look at when they're deciding whether or not you're disabled. Okay, so the very first step there is, are you currently engaging in what they call substantial gainful activity? Substantial gainful activity is, right now in 2022, means, are you earning more than $1,350 gross in wages per month? That's what substantial gainful activity means. If they find that you're making more than $1,350 before taxes, this is just gross income per month, then you will not be eligible for Social Security disability benefits. Now, there may be some exceptions. Sometimes there's what they call countable and uncountable income. So certain kinds of income won't be counted. They typically won't count, food stamp benefits you might receive, and other a whole array of category of types of money may not go towards that. But just as a rule of thumb, if you're making more than $1,350 in wages per month gross, then you won't be eligible for disability benefits, typically. And that's the same as true if you're on disability benefits currently. If you're on disability benefits and you find yourself able to go back to work, maybe first at part-time below that $1,350 limit, and then at some point you pick up enough hours or you find yourself able to work over the $1,350 threshold, then at that point your eligibility may come to an end. And that's a whole other conversation. A whole lot more goes into that, and it's not quite that cut and dry. But again, this is, as a rule of thumb, that's the number to keep in mind. Okay, so step 1, are you making more than substantial gainful activity? If not, we go to step 2. Severe impairment. So this goes back to what I said about the definition of disability. Do you have a severe impairment or combination of impairments that are going to last for more than 12 months? So when you think of severe impairments, I think sometimes people may be too narrow when they think of that, because you may have one or two conditions that may not be severe by themselves, but in their aggregate, when they combine, they may become severe. So I don't want people to be discouraged by the word severe or that kind of language, because we really find that some conditions people may not think of as severe, when combined with other conditions that they have, may amount to the level of severity that Social Security is looking at. Excuse me. Okay, so do you have a health condition or set of health conditions that are severe? That's step 2. If yes, then you go to the third step. Does it meet or equal one of the listings? So a listing, let's see if I have a slide here on listings now. So a listing is kind of what it sounds like. Social Security maintains a big list of conditions and specific definitions of those conditions that it says are so disabling that we actually don't even need to continue with the rest of the analysis. So this is a very, very rare to meet a listing. Some examples of listing would be a double amputation, complete blindness, those sorts of things, very severe conditions. Now it does mean I would encourage everybody to go take a look at it. Just, type into Google Social Security listings, and you can actually see them. They're posted on the Social Security website. I would encourage people to go take a look at that list, because there's some other conditions you may not think wouldn't think of necessarily as meeting a listing, but they do. For example, sometimes certain mental health conditions, schizophrenia, can arise to the level of listing. But you'll see when you visit that website that they have very strict requirements for what it means to have schizophrenia so severe that it meets a listing. Nonetheless, that's step 3. So again, are you making less than $13.50? Do you have a severe condition? And does it meet a listing? Now, if it doesn't meet a listing, that's okay. What happens next is you go to the next step where you construct what's called the residual functional capacity. So that is exactly what it sounds like, residual functional capacity, your remaining capacity to function and work. And so people are sometimes surprised perhaps by how detailed it is, but when they're putting together your RFC, so again, they're saying, Social Security is saying, okay, you have some severe conditions. Maybe it doesn't meet a listing, but you have severe conditions. You're not making substantial gainful activity. So what is your profile, your remaining residual functional profile, this individual's capacity? And so they actually build exactly that. They build a profile for each claimant, and they say, okay, so what is their age? What sort of education have they had in the past? Are they certified for any particular types of work? Do they have a welder certification? Those sorts of things. How high of an education did they attain? Did they go to college? Did they complete high school? What types of jobs did you do in the past 15 years or so? Were they heavy duty jobs, light duty? And then also physically, what your physical conditions are. So they'll come to a conclusion as to how many pounds you can lift. For example, can you lift more than 10 pounds at a time? Can you do that frequently? Can you do that occasionally? Do you have any fine or gross motor control issues? Can you put your arms above your shoulders? Are you able to sit in one place for more than 2 or 3 hours at a time? They'll really get that detailed when they're constructing your RFC, is what they call it. And so that's step 3, or 3.5 really, but they create the RFC. So then they take your RFC. Let's say that they've decided, despite your conditions, you have a light RFC. So they break them down. It's a heavy, medium, light, and sedentary RFCs as basic categories of RFC. And so let's say that they've decided that you have, as a claimant, have a light RFC, which means you can't lift more than 10 pounds occasionally, frequently. And other things like that. You can push 20 pounds, very specific things like that. And sorry, before I go on, I want to talk a little bit about the RFC a little bit further here. Sorry. They not only do they look at sitting, standing, walking, lifting, like I just said, they also look at your non-exertional limitations. And so that also means mental health limitations. So if you have a condition that means that you can't focus at a task for more than a few minutes at a time, they will consider that as part of your RFC. Perhaps you have a condition that means that you can't be in an environment that has a lot of dust or a lot of noise, those kinds of things. And also postural limitations, stooping, bending over, climbing, those sorts of things. All of that will go into your RFC. Okay, so then they say, now given this RFC, if this person has a light RFC, can they do their past relevant work? So let's say previously you worked in a warehouse where you had to lift 50 pounds all the time, or frequently lift 50 pounds. Well, then no, if you have a light RFC, you're not going to be able to lift 50 pounds frequently anymore. So then you can get past step 4. Does this person have can they perform their past work? No, they can't. So then finally we arrive at the fifth step. Sorry, don't have a separate slide for that. So then you arrive at the 5th step. Can you perform any other work in the national economy? And this is often the hardest step to overcome because they really are going to look at any other types of jobs. There is what we call, colloquially, the big book of jobs, where they actually have a collection of all the job categories, or most of them rather, in the United States, from folding clothes to working in warehouses, to different types of IT jobs, and they're going to look at the physical requirements of those jobs. So even despite your past work, so maybe you worked heavy jobs in the past, but now you have a light RFC. So they're going to look at, could you perform any light jobs in the national economy? What sort of jobs could you perform? So let's say you have a light RFC, then in addition to that light RFC, you have other limitations. So you have light RFC, but also in addition to light RFC, maybe you have severe manipulative limitations. Perhaps you were to have a condition that means that your hands can't type on a keyboard or do other manipulative activities like that. Does that preclude you from doing any other jobs? And your age comes into play here in a big way, because the older you are, the less strenuous of a job they expect you to be able to do. So if you're over 55, they're not going to expect you to be doing medium or heavy jobs or even light jobs. So you only have to prove that you can't do sedentary jobs. Or that you're limited to sedentary jobs. But as you can tell, there's a lot more into this than what I'm talking about. This is kind of just meant to give you an overview of how they analyze a case. So let's say, now that we've talked about that, those medical, how they analyze a case medically, they go through the 5 steps about whether or not you're working under SGA, whether or not you are have severe impairments, if they meet a listing, if they don't meet a listing, what your RFC is, can you do your past work, and can you adjust to do any other work? So if you believe that this is something you'd be interested in, now that you've thought about how they look at your case, and you believe that you won't be able to work other jobs, here on the screen is a couple different ways to apply. You can apply by calling their phone number. I would recommend people try to apply online because it's easier to create an online account where you can track the status of your application. Or you can submit some forms if you prefer to mail in these forms, or go in physically to the office and do it in person there. Until recently, the offices were closed because of COVID, but I think most of the offices have opened up back now, the local field office. So if you feel most comfortable doing it in person, I'd recommend you contact your local field office. Just Google Social Security field office in your area and ask for a time to go in and complete an application. Okay, so let's talk a little bit about the hearing process now. So let's say you've decided to apply for benefits, and you're worried about how your application is going to proceed from there. So everybody, I think, should be aware, and this is, I think, this is pretty common knowledge, but a lot of applications, majority, more than 50%, right there as it says on your screen there, 65% of applications are denied at the first level. So I don't want people to be too discouraged if they get denied at what we call DDS, Disability Determination Services, the local level. If you receive a denial at the local level, if you're one of the 65% of people that receive a denial, then you can submit a request for reconsideration, is what it's called. And that's where it's sent to another group of evaluators, who are going to review the first group's work and see if they missed anything or did anything wrong. Maybe look at additional medical evidence you could submit and make a new decision on your case. Reconsideration, exactly what it sounds like. And again, another 13% of those cases end up getting allowed at that level. But really, we find the most success in terms of appeals at the 3rd level, at the ALJ level, Administrative Law Judge. So as you can see on the screen there, that's where the numbers finally shift a little bit better. So they allow 45% of cases or so at the ALJ level. So 65% were denied originally. Of that 65%, 13% that appealed get allowed. And then after that, 45% of the remaining denials will sometimes get granted at the ALJ level. And that's where you're going to have sometimes your first opportunity to really get in front of someone and talk to them beyond instead of just relying on the materials you've submitted and your application. It'll be the first time that you'll be able to be in front of a judge, an administrative law judge, perhaps with an attorney at your side, to really talk about your experiences with your conditions. I'll go into that a little bit more in the next slides. But after that, you can submit, if you get denied at the ALJ level, there's still levels of review beyond that. If you're denied at the ALJ level, you can submit what's called a request for review for the appeal council. And then after that, you can proceed, of course, to the federal courts. But as you'll see there, the numbers become dramatically less in favor of claimants. Only 1% of cases are allowed at the Appeals Council and 2% at the federal courts. That's not meant to say that it's impossible or that you shouldn't appeal necessarily. Social Security gets cases wrong from time to time, and I'd certainly encourage you to appeal if you feel like it's appropriate. But I think it's good to just have an awareness of the percentages of allowing and denying allowances and denials at each stage. And so here we get a little bit further into detail about how those stages are broken down. So at the first level at DDS there, you submit your medical records. They create an initial RFC, as we talked about. Sometimes they'll send an RFC to your doctor to complete, where the doctor fills out a form saying what he believes your remaining functional capacity is. Sometimes they'll send you out for what's called a consultative examination, a CE, where they send you out to a doctor, an independent doctor that Social Security pays to get an independent perspective on your conditions. And that independent CE will complete an entire write-up about your conditions, where he says what his or her opinion is of your RFC. Down there at the bottom, that consultative exam. And so, yeah, so that's what it looks like at the initial level. You submit your medical records, you submit answers to questionnaires about your conditions. You submit you may go in for a CE exam, and maybe your doctor submits something on your behalf. That's going to be what your file consists of. That's what they're going to look at Social Security. Let's say now, so that at that level, if you get denied, you have 60 days to appeal. Most of these deadlines at Social Security are going to be 60 days, but I think as a rule of thumb, it's better to just treat everything as a 30-day deadline, because those 60 days can sneak up on you real quickly. And I think just as a rule of thumb, it's best to just act as if you have 30-day deadlines. Anytime you get a denial or request for information or anything like that, just try to get it done as soon as possible, within 30 days or less, most of the time. And so if you are denied at that initial level, you'll submit what's called a request for reconsideration. You can go into the field office again and ask for help filling out that form. It's a very short form, just a few pages. You can submit new medical records, like I said, for reconsideration. But let's say after that, your reconsideration is denied again. Again, there's the 60-day deadline for a request for a hearing before an administrative law judge. And those usually get scheduled, well, right now they're getting scheduled, I think, within 12 months or so in the North Carolina area. Sometimes it can take much longer. So this is really where things start to drag out. We find this is where it most commonly tends to drag out. So, I think Social Security, rightfully or not, has a reputation for taking a long time to do most things. And this, I think, is perhaps the source of a lot of that reputation, because when you submit a request for a hearing, that's really where the length of time is going to stretch out, because you might get a hearing within just a few months, but most of the time it can take much longer than that. And so you have a right to an in-person hearing. And I think a lot of people choose to have an in-person hearing because people feel like, the judge will have a greater appreciation of the severity of their conditions if they can see them in person and see how much they're suffering or how difficult it is for them to get around in person. But if you don't feel comfortable with an in-person hearing, you always have the right to request a telephone hearing as well, or a video hearing with their Microsoft Teams system that they use. Telephone hearings may be more appropriate for other people, so it's entirely at your discretion. But in any case, you'll get a notice of hearing 75 days before the hearing. And so that gives you 75 days to get in any additional medical records you want to submit. Make sure you do or don't have representation, and those sorts of things like that. But that's the next stage there. Now, should you get an attorney? Typically, we recommend people seek legal advice when they're applying for Social Security benefits, but especially so when you're at the ALJ stage. Now, not everybody needs an attorney, but it can certainly help, especially if you are able to find an attorney with experience in the field. Now, you may be concerned about being able to pay for an attorney. That's one thing you usually won't need to be as concerned about if it's an initial application, because attorneys in Social Security are typically paid, not always, but most of the time. The fee agreement is just for a percentage of your retroactive benefits, or back pay, as it's sometimes called. So I think this is an important thing to talk about because I feel like some people may be discouraged from seeking out an attorney for their appeal because they're worried about the pay. So the way pay works most of the time for Social Security attorneys is that they get it out of their back pay. And so what I mean by that is that let's say you applied for benefit. You first applied. You submitted your initial application on January 1st of 2020, and you got denied. 4 months later, let's say, at the initial level, and then you got denied for reconsideration another 4 months later. 8 months has already passed, and then you apply for a hearing. You request a hearing. And maybe it takes another 6 months to get a hearing. So at that point, you're already at inching up on 18 months or so, or whatever it is, 12 months, I guess. Getting close to 14 months. 14 months. Can't add right now. 14 months have already passed, and let's say you get to that hearing and you're successful at the hearing. And the judge awards you benefits and says, actually, you should have been found disabled originally when you first applied on January 1st of 2020. Well, that means that you would have retroactive benefits going all the way back to January 1st of 2020. And so let's say you should have been paid, $800 a month, each month, all the way back for 14 months. That's where your attorney's fee would come from. It would come out of a percentage, 25%, or up to $6,000 tops, out of those 14 months of back pay benefits. And here at Legal Aid, we generally don't take any percentage, of course, from individuals' back pay. So this is for private attorneys only, not for Legal Aid. We don't request any portion of your benefit, retroactive or otherwise. But that's how attorneys are paid through this process. Okay, so now let's say you finally arrived at the ALJ hearing. It took you 14 months to get there, but we're finally here. So what is it like? What is it like to be in an ALJ hearing, a Social Security hearing? Well, at the hearing, the judge will swear you. Start at the very beginning. The judge will swear you in swear to tell the truth, nothing but the truth. And then the judge and your attorney, if you're represented, will ask you a series of questions about your medical records and your experience with your conditions. So your medical records will generally provide the basis for the specific medical details, the nitty gritty of your medical issues, like how much albumin is in your blood levels, for example, if it's a liver disability, if your disability has an issue to do with your liver. But what your role at the hearing will be is to talk, usually what your role at the hearing, your primary role, will be to talk about how you experience those conditions and how they limit you. So at the hearing, you're going to be your best capacity there is to provide testimony about how, for example, you can no longer do laundry because you can't move your hands in a certain way or move your arms in a certain way, or how you can't, your finger manipulation is so restricted that you can't use a remote control for a television. Or talk about the severity and duration of any panic attacks you experience. If you experience panic attacks, perhaps as part of an anxiety disorder, that's going to be your role at the hearing, is to talk about how those limitations really impact you on a day-to-day basis. It's also an opportunity to make sure that the judge understands the full array of your conditions. Maybe the judge didn't notice in the records, or lower level reviewers didn't notice certain aspects of your condition. You really want to highlight that, and you believe that it was overlooked. This is going to be your opportunity to really testify and put your case, your narrative, your version of events, and how you experience things before a judge. So after you've presented that testimony, then the judge will turn to what they call a vocational expert, which is a jobs expert, and ask them what they think someone with your conditions would be capable of doing. If there are any jobs that someone with the conditions that have been talked about there at the hearing and the limitations there, what sort of jobs would still be available to you, or whether or not you can perform your past jobs. That's the second part of the hearing, is the vocational expert part. So again, you go in, you provide your testimony, then the judge gets testimony from a vocational expert, and then finally, your attorney or yourself may provide a closing statement, perhaps, sometimes an opening statement to back up about why they believe that you should be qualified for disability benefits. So now if you elect to have an in-person hearing, it'll be within 75 miles where you live. So if you're in North Carolina there, if you're in the Greensboro area, there's a Greensboro office of hearing, Greensboro hearing location, a Raleigh hearing location, a Charlotte hearing location. That's generally where it's going to be, within your closest hearing location there. Make sure to arrive as early as possible, especially right now. They have really strict COVID screening procedures. So make sure to discuss those COVID screening procedures with your attorney if you have an attorney, and be prepared to wait a little while outside the hearing as well. Here's some more advice or information about testifying before the ALJ. Always be honest. It's really important that you do either underplay or over-exaggerate your conditions, especially in some circumstances. We find that people may even be denied if they provide a testimony that conflicts what's on the medical record. So if in the medical record, it states that that you require a walker, but then you say at the hearing that you don't require a walker, or vice versa, that may present some concerns to the administrative law judge. So make sure that what you testify to is consistent with the medical record and is honest at all times, of course. Be as specific as possible. So sometimes it's really easy for claimants and anybody really to not realize how specific they might need to be for somebody who isn't experiencing what they experience. So you might say something like, well, my legs hurt all the time. But really, it's a lot more helpful to really get into the details of how that pain feels. So don't just say, or it's best not to just say, my legs hurt all the time when I'm standing, or whenever I stand, my legs hurt. It's best to say more specifically how long you're able to stand up despite that pain, or how you experience that pain. Is it a dull throbbing ache in one side? Is it a shooting, extreme, sensitive pain? Where is it located in your leg? Those sorts of things. Be as specific as possible when you're testifying about your conditions. Make sure you get all your medical records in. There's what we call the 5 business day rule. So make sure that everything is submitted 5 business days before the hearing, longer if possible. And then make sure that you're prepared to talk about your educational background. So whatever your highest grade completed was in school, any vocational training, licenses you might have, those are all things that can come up, especially your work history. That's another thing that's important. Like I said, they're going to look at the last 15 years of work history as a rule of thumb, maybe not exactly 15 years, but about 15 years. And it's also important to make sure you note that if your past work was different than how it's typically performed. So maybe you worked in a job that typically would not involve heavy lifting. But for whatever reason, your specific role at that job or whatever particular reason at that workplace, you ended up having to lift a lot more than most people did for that job. That's important to note because they want to know how your job was, how difficult your job was physically as it was actually performed, not just as it is on paper. So it's important to mention that sort of thing, what specifically you did at your last job. Medications, side effects of medications, sometimes those get overlooked. Any sort of medical equipment that you use, canes, walkers, braces, even informal medical equipment, maybe if it wasn't prescribed because you have difficulty seeing a doctor, but it's something you do rely on a regular basis. Your daily activities, what kind of help you need to get around and do your daily activities, and potentially a witness if you feel like it would be very helpful to have a witness at the hearing. Perhaps if it's someone who has a legal guardian, the legal guardian is sometimes an appropriate person to have at the hearing, things like that. So you go to the hearing, go through your testimony, decision. You're in the hearing, usually they last an hour, maybe a little bit longer. What can you expect next? Well, next is the decision. You'll get a written decision that's usually pretty lengthy and pretty detailed, typically. They usually come within 2 to 3 months of the hearing, where the judge is going to go through all the facts that they heard, and the facts from the medical record and your RFC, and really go in great detail why they believe you are or are not disabled as defined by Social Security. They're also going to say, if they approve it, what the date of the onset of your disability was. Perhaps they agree with you as the date you applied, but it may be a later date or an earlier date, perhaps, depending on your testimony and the facts of the case. Or if you're denied, at that point, you can appeal. Like I said, there's another level of appeal beyond this. The next one is called the Appeals Council. And again, you have 60 days there to appeal further. Okay, so let's say you've been awarded benefits. You go to the hearing and the judge finds in your favor and awards you benefits. What happens next? That's unfortunately a good question to ask, because it's not the end of things. You can't just expect. I think sometimes people think, okay, I've been awarded benefits. That's the end of the story. Now I can go back and just live my life and receive these benefits. But the truth is that you're going to have to consistently work with SSA going forward. So if it's a child case, when they reach age 18, there's a mandatory redetermination at age 18 to see if that individual is now disabled under the adult rules for disability. People who are adults who receive disability are going to see a similar thing where every 3 years or so, you're going to get what's called a continuing disability review, or CDR. So every 3 years, approximately, Social Security is going to want to make sure that you are still disabled, make sure that you're to see if your conditions have improved or not. And that is something that people can be surprised by. You know, suddenly going to see a doctor Social Security sends you to, and then a couple months later being told that you're no longer disabled because that doctor decided that your conditions have improved. And then finally, there's the issue of overpayments. So like I said, some people are able to work a part-time job while on disability, or there's other circumstances where they come into money, perhaps they inherited money or some other issue like that. And that can cause what's called an overpayment. So if you work and maybe you don't report those wages, Social Security, it's important anytime you work where you're on Social Security, you need to report those wages on a monthly basis. It's very important to report any wages or money that you receive on a monthly basis, not just at the end of the year. And so you're going to want to watch out for that, because let's say you received some wages over the income limits for several months at a time while you were on benefits, and Social Security, and you don't report it. Well, Social Security may discover that later on when they find out that you received, through their communication with the IRS or however else, they find out that you received income when you were receiving benefits that you shouldn't have, or for whatever reason. They're going to issue what's called an overpayment, and they're going to require you to pay that money back. So let me see if I have more of that now. So if you receive an overpayment, that's also something you could reach out to us here at Legal Aid about, because there are ways to contest an overpayment. Sometimes they get it wrong, or to request a waiver of the overpayment. But that's another topic for another clinic. But people should just, for now, I just want people to be aware that even when you receive benefits, your interaction with Social Security doesn't end there. You're going to need to report your wages, report any assets that you receive, and be aware that every 3 years or so, you're going to go back in for a review of your conditions. Okay, so how can you receive help? First of all, Legal Aid, of course, we're here. Our number is there. Give us a call, and we'll see if we can help with your case. I definitely recommend the lawyer referral services there posted to see if there's any private bar attorneys that will be able to take your case. And then we recommend people seek out medical care, of course, not only primarily above all things for your own health, to seek medical health as much as possible, to seek care for your conditions. If you're at a point where you're considering disability benefits, of course, you have severe medical conditions, and there are some resources there to seek out medical clinics. But it's also important to go to medical clinics, or at least the benefit of going to see more medical clinics or medical treatment is that it helps develop your record, because it's important to have medical records that provide objective evidence of your conditions, so you don't have to just rely on your own testimony. You're able to rely on records there. So a few last comments about changes from under COVID. Until recently, as Social Security offices were closed, and we kind of had to do everything online or by mail. That's not the case any longer. Most Social Security offices are now open. but everything's still a little wonky. So make sure you call your Social Security office ahead of time before you go in person, or look them up on the on their website to see if they have any special procedures. They're doing in-person hearings again now. Until recently, they're doing everything over the phone, but now they're doing in-person hearings again. And so finally, I just wanted to make everybody aware, as our last slide here, that while you're considering disability, reach out to, we have a free navigators here, healthcare navigators, to see if you might be eligible for a free or low cost Obamacare enrollment plan, Obamacare enrollment. So definitely check that out as well. Right there, and the phone number, and I encourage everybody to check out our navigator program. Okay, well, there's our contact information and another contact information for the lawyer referral service. So if you have any questions, I'd be happy to answer them now. Let's see here. Give it just a few minutes to see if anybody has any questions. Okay, well, not seeing any questions. Happy to end the program there.
Cool. I'd just like to say on behalf of everyone, thank you so much for your time, Robert. I know that people really appreciate it, and hopefully are finding benefit from these clinics. So we can end it there. Have a great afternoon, everyone. Bye-bye.
Bye.